Welcome to Immigration Talk with Attorney Anish. Attorney Anish is an immigration lawyer who has been certified as a specialist in immigration and nationality law by the State Bar of California's Board of Legal Specialization.
Hello everyone, it is April 11th, 2020. My name is Anish Bashista and you're listening to Immigration Talk with Attorney Anish. For those who are watching the video, then you're also watching Immigration Talk with Attorney Anish. This is the third part in a series of recordings that I'm doing to assist people who are in the United States, or for some who are outside the United States, trying to find a way back in, suffering from the COVID-19 crisis that is gripping the world right now. I previously discussed how one can search his or her USCIS case status and what can be done to move the case along if it's been pending beyond the standard processing time. Last time I discussed what the current operations for the various immigration-related agencies and sub-agencies are under the crisis. And today I wanted to talk about what one can do if his or her status has been terminated unanticipatedly and is otherwise unable to return to his or her own home country. I've been receiving a lot of calls about this subject where people have been laid off from their jobs and consequently had their H-1 status terminated, or had their non-immigrant status terminated as a result. In the H-1 context specifically, and in other employment-based non-immigrant contexts, one could see that you get a 60-day grace period from the date of termination, assuming that there was 60 days remaining on the petition's time frame to begin with. But sometimes that 60-day grace period has already been used up, where the person tried to find another job but couldn't and is now out of time. Or they already had a pending extension. They had an extension request pending and went beyond the expiration of their prior petition and was expecting the extension to be approved, but now that's not possible because the employer has laid them off. So I kind of wanted to go over some basics first before telling people what to do. Now, if we go to the regulations, and that's the Code of Federal Regulations relating to immigration, for short we'll call them CFR. The first one I wanted to go over is 8 CFR. So I'm going to go ahead and change the tab here. And right now we're looking at 8 CFR 214.1. And under 8 CFR 214.1, there is a guidance on extensions. Now this is specifically for extensions of stay. So for example, if you entered as a B2 visitor, or you entered as an H1 and your spouse entered as an H4, and you needed an extension, then for the most part, as people understand, you need to file that extension request before the expiration of your current status. And that's what, for the most part, it says here. Under subsection 4, it says timely filing and maintenance of status. It says an extension of stay may not be approved for an applicant who failed to maintain the previously accorded status, or where such status expired before the application or petition was filed. So that's the general rule. Was filed. It had to have been filed on or before your current status expired. Otherwise, your extension request is untimely and it may not be approved. However, and this is the however part that many people miss, there is an except phrase. When it comes to law, there is a rule and there's an exception. You either argue the rule or you argue the exception, or sometimes you argue both in the alternative. In this situation, there is an exception. Except that failure to file before the period of previously authorized status expired may be excused in the discretion of the service. The service is United States Citizenship and Immigration Services. And without separate application, so there's no additional form, but you do need to make the request either on a piece of paper or within the form somewhere, however you can, with any extension granted from the date the previously authorized stay expired. So that means that the approval of the extension, if it is indeed approved, would be backdated to the expiration of the previous status. And so sometimes I would even put in the application, I would put a date that happened in the past, because that happens to be the day that the previous status expired. But whether you do that or not, in the end, if USCIS approves it, then it's going to be automatically backdated per this regulation. but you have to prove certain elements. So you have to demonstrate. So it says where it is demonstrated at the time of filing that. So when you file the extension request, it has to be demonstrated that the delay was due to extraordinary circumstances beyond the control of the applicant or petitioner. And the service, again, that means USCIS, finds the delay commensurate with the circumstances. So there was a delay, obviously, otherwise you wouldn't have filed it untimely. The delay had to be due to extraordinary circumstances, and whatever the delay was, it has to be commensurate, or it has to be reasonable when taking into account those extraordinary circumstances. So if you're going to say like, oh, I forgot to put a stamp on the envelope, and that's why I'm filing this application a year late, one, that may not be an extraordinary circumstance. And two, even if it were, that's not necessarily commensurate with, waiting a year to file something is not commensurate with forgetting to put a stamp on the envelope that, containing the extension application. So just keep that in mind. Second, the alien has not otherwise violated his or her non-immigrant status. So that's very important too. So if you were here as a visitor and you worked without authorization and you want to file your extension request late, well, even if you have extraordinary circumstances and even if the delay is commensurate with those circumstances, you still otherwise violated your non-immigrant status by working without authorization. So you don't meet the requirements for the exception. 3, the alien remains a bona fide non-immigrant. So you still have to maintain the position that you have an intention of returning to your home country. You're not looking to reside permanently in the U.S., except for the categories that allow dual intent. And then 4, the alien is not the subject of deportation proceedings under Section 242 of the Act, which is the old deportation proceedings before the change in the law, or removal proceedings under Section 240 of the Act, which is the current legal scheme for pursuing the removal of people from the United States. So if you're not in removal proceedings, you're not in deportation proceedings, then you're allowed to pursue this if you meet the other 3 requirements. Now, that is for people who are trying to extend their status. Now, what I'm hearing about are people who we're here in H1 or some other non-immigrant, especially employment-based non-immigrant status, and they're being laid off. And now they need to file a request to change to visitor status just for enough time so that they can wait for the crisis to pass. And especially for people from certain countries like India, where you can't even go back there. They need time to be able to stay here lawfully, preferably, before they're even allowed to return to their home country. So this is specifically for an extension. 8 CFR 214.1 is for an extension. But let's look at the rule for a change. So this would be good for people who wanted to change from H-1B to B-2. Remember, H-1B is a temporary worker, and B-2 is a visitor for pleasure or for tourism. So let's look at the regulatory subsection. It's 8 CFR 248. 0.1. So 8 CFR 248.1 B, it says, and this is specifically for changes of status, except in the case of an alien applying to obtain V non-immigrant status, which for the most part doesn't really apply to people who are listening. A change of status may not be approved for an alien who failed to maintain the previously accorded status, or whose status expired before the application or petition was filed. Okay, so same general rule. If you want to extend or change your non-immigrant status, then you need to file the application before the expiration of your current status. Makes complete sense. There should not be a gap. Except, again, now we have an exception to the rule, except that failure to file before the period of previously authorized status expired may be excused in the discretion of the service, again, that means USCIS, and without separate application, where it is demonstrated at the time of filing that application. 1, the failure to file timely was due to extraordinary circumstances. There we see that wording again. Beyond the control of the applicant or petitioner. And the service finds the delay commensurate with the circumstances. 2, the alien has not otherwise violated his or her non-immigrant status. Again, such as you didn't work without authorization. 3, the alien remains a bona fide non-immigrant. And 4, the alien is not subject to removal proceedings under 8 CFR Part 240. So if you meet those requirements, then in the discretion of USCIS, you can be granted what we call an untimely change of status. Similarly, you can be granted an untimely extension. So, for example, if you are here on an H-1 and you filed an extension request of that H1 status, and then you got laid off. But while that extension request was pending before you got laid off, your previous H1 petition expired. Now, we all know that you're allowed to remain here in the US until a decision is made on that extension request. But now that extension request is basically going to collapse because the employment underlying it has been terminated, right? So everything falls apart. So in that circumstance, you're out of status, and you don't get the 60-day grace period, or if you did, it already passed, right? So what can be done? I would suggest if you meet these requirements, you can go ahead and file an untimely change of status to visitor status, stating that you were planning on departing as soon as you got laid off, but you can't go back because your home country has been shut down, and you just need a little bit of time so that you're not accruing unlawful presence, and so that you can leave on time. This happens also if you didn't even have an extension request pending, but you got laid off and you're in your 60-day grace period and you booked your flight, and then all of a sudden, 2 days before your grace period ends, when you were supposed to leave, the flight gets canceled and you're not allowed to go back at all. And you're not knowing what to do, so instead of doing anything, you kind of just sit in your house wondering, what am I going to do? Well, that's not the right approach. You should contact a lawyer. But if you didn't, and the 60-day grace period has expired, and now you're out of status, and now it's too late to file a timely change of status application, well, you know what? You can still file an untimely change of status application, but you need to make sure that you make the specific request that it be granted in USCIS's discretion despite its untimeliness, and you address these for requirements for that discretionary excusing of the timely filing requirement. So those are some things to think about. Now, if you're wondering, what impact does this, let's say it's approved, what impact does that approval have on future filings? So USCIS addresses this issue too, and I'm going to address specifically when you apply for a green card, because this comes up. Someone previously had an untimely or untimely extension or untimely change of status granted, and they were here, say like in B2 status, after an H1 got terminated, and then while they were here in B2 status, they found another job, and then they switched back to H1B status. But then when they apply for adjustment, whenever, say like they get an I-140 approved and it becomes current, they apply for adjustment, which is applying for a green card here in the US, and they get an RFE saying, hey, it appears that you had status up until such a date, and then you had status again for that commenced on the date that was 1 or 2 months after the expiration of the prior date. As you know, under INA section 245C, if you don't continuously maintain non-immigrant status, you're ineligible to adjust. So USCIS does address this in their own practice manual, specifically in chapter 4, which we'll get to. Effective extension of stay and change of status. Now this is specifically for, I'm going to scroll up here. This section is for status and non-immigrant visa violations. And this is specifically under the category of 245A adjustment. 245A adjustment is the adjustment that most employment-based and family-based immigrants go through. So I'm going to scroll back down to where we were. I don't want to get you guys confused with other categories or other subsections under this. So let me just find out where we were. No, we don't want to go there because the law on that has changed, and I'll discuss that in a future post. Here we go, back to 3. Effective extension of stay and change of status. At the time of adjustment, at the time that you're going to be granted the green card, or at the time that the decision is being made on whether you're going to be granted the green card, an officer must consider all of the applicant's current and previous entries into and stays in the United States, including current and previous applications for extension of stay. They call that EOS, or change of status, which is called COS. Okay, fair enough. Officer has to take all that into account. The following examples provide more detail on the effect of EOS and COS applications on a pending adjustment application. So first, I'm going to talk about timely filed applications to extend stay granted by USCIS. So when USCIS approves a non-immigrant's timely filed application to extend status, the start date of the extended status is retroactive to the expiration date of the initial or previously extended period of status. USCIS's practice of making the approval effective as of the prior expiration date recognizes that the non-immigrant has been maintaining the same non-immigrant status throughout the processing and adjudication of the extension application. So that's very important to understand. And this question comes up every now and then. So I'm in status that it's going to expire, say, on April 30th. I filed my extension application on April 29th. April 30th passes, and my extension application reasonably has not been adjudicated yet. Am I illegally in the United States? Well, if that extension application is ultimately approved, even if it's approved 2 months later, yeah, everything's fine. There's no gap. That extension approval would be backdated to April 30th. They may not say that on the notice, but per USCIS's own policy, it is. So just keep that in mind. But we're not talking about that normal scenario where extension applications are pending, have been filed timely, and are pending beyond the expiration date of the previous status. We want to get to untimely. Well, let's finish up what we have to see with timely filings. Now, they have an example here where on January 1st, 2009, an alien is admitted to the United States as a visitor. June 30th, the authorized stay on their Form I-94 expires. But a month prior, on June 1st, they filed a timely extension application. On August 1st, the extension application, on August 1st, the B2 non-immigrant files an adjustment application. That's the application for the green card. On September 1st, USCIS goes ahead and grants the extension that was filed back on June 1st. In this scenario, USCIS considers the alien to have continuously maintained lawful status for purposes of adjusting status. In contrast, if USCIS denied the extension application that was filed on June 1st, then the alien would have fallen out of status as of June 30th and would be barred from adjusting status unless an exemption applies. So then there will be a gap of about a month from June 30th to August 1st, and therefore the alien would be ineligible to adjust status. Now, this example, while technically correct, is practically something that wouldn't happen, because if you're filing for an extension and your extension application is pending, most immigration lawyers would tell you don't file for adjustment of status because that extension application most likely would be denied. And if it's approved, it would be approved by the adjudicating officer without that officer knowing that you would file for adjustment, and it may come back to bite you when it's discovered that the officer didn't know that you were applying for adjustment at the time that the officer granted the extension. Just things to take into account when it comes to non-immigrant and immigrant intent. For a B2 extension, you still need to maintain non-immigrant intent. The moment you file that adjustment application, you're showing you have immigrant intent. So just something to take into account for practical purposes. The same rule applies for timely filed change of status applications. When USCIS approves a non-immigrant's timely filed application to change status, the start date for the new non-immigrant status is effective on the date of approval. The start date acknowledges the fact that USCIS only authorized the non-immigrant change of status as of the date of approval. If a gap of time exists between the expiration date of the previous non-immigrant status and the start date of the new status, USCIS still considers the non-immigrant to have continued to maintain a lawful status only if the non-immigrant timely filed a change of status application, so it's timely, USCIS granted the request, and the non-immigrant did not violate any terms and conditions of the initial status, right? So if it's a timely filed extension or a timely filed change, then everything's fine as long as that extension or change is approved. And then they give another example where someone files a change of status application before the filing of the adjustment, and if the a change of status application is approved, then the adjustment is permitted to be approved as long as there's no other violations. We see this not only in the context of adjustments, which is green card applications, but subsequent change and extensions. So if someone files a change and they file another change while the first change is pending, or in the context of an extension, or they do an extension and a change, the subsequent change or extension can only be approved if the first change or extension is approved. Otherwise, there's going to be a gap, right? Now, let's turn to the issue of that many people are facing today, filing an untimely one, right? An untimely change or extension application. What's going to happen if the change or extension application is even approved, but it was still filed untimely? In that scenario, we have to look at what can be done, right? So let's go ahead and do that. Untimely filed EOS or COS application excused and granted by USCIS. USCIS generally denies EOS, that's extension, and COS, that's change, applications when the applicant failed to maintain non-immigrant status or when the applicant status expired prior to filing the application. Now, we already read the regulations. We know there's an exception. And that's what they're going to go over right now. If an applicant's non-immigrant status expires before he or she files an application to extend or change status, the application is not timely filed. USCIS has discretion to excuse the untimely filing and approve an EOS or COS application if the applicant can demonstrate that. And then we're going to go through the requirements. The delay was due to extraordinary circumstances beyond the applicant's control. The officer finds the delay commensurate with the circumstances. Now, in the regulation, that's combined into one requirement. Here, to make it easier in the manual, they make it into two. The applicant has not otherwise violated his or her non-immigrant status. For example, the applicant hasn't worked without authorization. The applicant remains a bona fide non-immigrant, and the applicant is not in removal proceedings. Okay, clear. As with a timely EOS or COS application, if USCIS approves an untimely filed application to extend or change status, the approval is effective as of the date of the expiration of the prior non-immigrant admission period. For this reason, USCIS considers the applicant to have maintained lawful status despite the gap in time between the expiration of the prior non-immigrant admission and the date of approval. Great. And then they give another example where someone was admitted on January 1st, 2009, our B2 non-immigrant visitor. Their status was going to expire on June 30th. They went ahead and filed the extension more than a month late on August 5th, 2009. But in the application, the applicant explains that he or she was unable to file the extension request timely because he or she was hospitalized with a debilitating medical condition when the status expired. And then there's corroborating evidence that's provided to it from the attending medical staff at the hospital. So on September 1st, 2009, USCIS went ahead and excused the untimely filing and approved the extension of status application. And this same scenario can happen with a change of status application. In this scenario, USCIS considers the alien to have continuously maintained lawful status for purposes of adjusting status. For purposes of adjusting status is very important. So that means that if the foreign national subsequently files an adjustment of status application, meaning applying for a green card within the U.S. based on an approved I-140 or I-130, something that requires a continuous maintenance of status, then even though there was in the past an untimely application for extension or change, because that untimely application was approved, the foreign national can still adjust status, and because there's no determination that there was a failure to maintain non-immigrant status. However, in contrast, if USCIS denied the extension application, the alien would have fallen out of valid status as of the original expiration date of June 30, 2009, and would be barred from adjusting status unless an exemption applies. We're not going over the exemptions. So that is something to think about, especially for people who have fallen out of status, no longer are in the grace period, or approaching the expiration of that. This COVID-19 crisis was unanticipated by many people. I would call it an extraordinary circumstance. And if you didn't work without authorization, not in removal proceedings, and you remain a bona fide non-immigrant, then I think you have a really good chance if you move quickly, because remember, the delay has to be commensurate with the circumstances. And just because there is a COVID-19 crisis, it does not mean you have an unlimited amount of time to file your change or extension application. So that is one regulatory addition that it's not even in the statute that Congress passed, but USCIS authorizes this for people who are not in status to still get an extension or change of status. And I think people who are in a situation where they may not be able to return to their home country and have already fallen out of status or are soon to do that should definitely jump on these regulatory elements that USCIS follows, take advantage of them, maintain their status, so that they don't find themselves in a horrible situation when the prior date for their I-140 or I-130 becomes current, or when they're applying for a visa outside the United States. Anyway, stay tuned for the next video and recording. I don't know yet what it will be about. Again, I'm always open to ideas, so please feel free to comment or send me messages. But for the most part, it's going to be about something that I'm being asked a lot about, specifically because of the COVID-19 crisis. This is Anish Vashista, the law firm of Anish Vashista, and thank you very much for listening and for viewing.